I want to talk today about a case that shows the need for buy-sell planning. It's a court case out of the Second Circuit, and it continues the theme that we started with some other webinars in recent months on the theme of comprehensive buy-sell planning. And if you've got an interest in the buy-sell planning marketplace, you may find some of the information in this webinar and some of the other webinars that are available on YouTube helpful.
Press 1 to play your message. Press 2 to enter your callback number. Press 3 to mark your message as urgent. Press 7 to re-record your message. Press star for the main menu, or press pound to exit. Press 1 to play your message. Press 2 to enter your callback number. Press 3 to mark your message as urgent. Press 7 to re-record your message. Press star for the main menu, or press pound to exit. Press 1 to play your message. Press 2 to enter your callback number. Press 3 to mark your message as urgent. Press 7 to re-record your message. Press star for the main menu, or press pound to exit. Press 1 to play your message. Press 2 to enter your callback number. Press 3 to mark your message as urgent. Press 7 to re-record your message. Press star for the main menu, or press pound to exit. Invalid entry.
So my apologies, everyone. Let's talk about this buy-sell planning case in about 10 minutes, which continues the theme of comprehensive buy-sell planning. You may find, by the way, that my book Sellout is helpful to you if you're interested in digging a little deeper in this market. We're going to review the case and its importance to life insurance professionals. And we're going to talk in a little bit of detail about the Smith Motors case, the Second Circuit court case that reinforces a recurring theme that we've hit before. First of all, the buy-sell market is important and potentially profitable for you. It provides opportunity. If you take a comprehensive approach to buy-sell planning, it differentiates you from others and increases your potential value to your customer. And that in turn allows you to serve your customer better. Our business owner clients need help in thinking about turning their business into money at a critical time, and to the extent that we can help them think of that, they'll think of us as consultants and added value in the process. To preview where we're going to conclude first, let me start by saying that the lessons from this case are these. First of all, a mistake in the way that a buy-sell agreement is written can interfere with its effectiveness. Secondly, a mistake in the structure of the buy-sell insurance can cause even the best buy-sell agreement to fail. Attention to detail is really what differentiates between almost working and really a smooth transition in a business. And finally, valuation of the business is an often overlooked detail. If you don't do it right in the buy-sell agreement, it can result in big problems for the folks who are left behind and for the folks who are not left behind. And today's case kind of demonstrates that situation. So let's talk a little bit about the facts of the P.K. Smith Motors case. P.K. Smith and his wife Marjorie and their sons Perry and Kenneth Michael Smith incorporated P.K. Smith Motors in 1989. After P.K. Smith's death, his widow Marjorie, along with sons Perry and Mike and their spouses, signed an agreement restricting the purchase and sale of P.K. Smith's shares of the corporation during the lifetime of the shareholder and upon the death of the shareholder. The agreement also provided for the disposition of shares in the event of divorce, death of a spouse, or termination of community property regime. Now, to sell shares during the lifetime, a shareholder was first required to notify the corporation, which had the option to purchase the shares. If the corporation failed to exercise its option, then the other shareholders had an option to purchase, and then thereafter, the divesting shareholder could dispose of the shares not purchased by the corporation or the other shareholders. Similarly, in the event of a death, the agreement granted the corporation an option to purchase all or any part of the shares that were deemed community property. Regarding the purchase and sale of shares upon the death of a shareholder, the agreement provided, and I'm quoting from the agreement, upon the death of a shareholder, the company, to the extent that it may lawfully do so, shall be obligated to buy, and such stockholders shall be obligated to sell, all shares of a company's stock owned by the deceased shareholder at his death. The purchase price for such shares shall be paid in cash within 60 days following the qualification of the succession representative of the deceased shareholder. Now, the agreement also included the following provision, which is reflected on the slide. The purchase price for each share of stock purchased pursuant to this agreement shall be blank unless and until such per share value has been superseded by a new per share value established by the vote of at least 75% of the total voting power of the company at the annual meeting of the shareholders. So what happened next? Marjorie died in 1997 and her sons became the sole shareholders of the corporation, each owning 50% of the share. One son, Perry, passed away in 2009. And in 2013, Perry's estate filed suit against Mike, the surviving owner in the company, seeking to discontinue the business and liquidate its assets, presumably because it thought that that would maximize its cash. The estate relied on a state statute which gives a court discretion to liquidate a two-owner company upon the death of one of the shareholders. Well, the surviving owner didn't like that. Mike argued that the original shareholder agreement, the one that we described and quoted some provisions from, should govern the sale of stocks, and it required the shares to be offered to the corporation and then to Mike. Mike offered to purchase the shares in accordance with the agreement, and Mike proposed that the court determine the value of the shares. Remember, the shareholder agreement left the value blank. Mike said, well, let the court decide, and he would either agree and purchase the shares, or he would agree to the liquidation that the estate was seeking. The estate argued that the agreement was unenforceable because it lacked a purchase price, so the court should exercise its discretion and order a liquidation rather than try to figure out the value. Well, the court went down the path of trying to figure out the value. It heard the testimony of several experts on the value of the business, along with the two parcels of real estate that the business offered. Several of the experts used different valuation methods and determined different values. That should be a surprise to nobody who works in the buy-sell market, because the agreement lacked a definition of a method to be used to determine a fair value. And so after several days of trial testimony, the trial court determined that the fair value of the company was $1 million and set the purchase price for the estate's half interest at $500,000. The estate appealed, again arguing that the agreement was unenforceable because it did not have a purchase price, and it did not define a way to determine that price. But the appeals court affirmed the finding of the lower court, and it said that the agreement set out the process for selling and purchasing shares at a shareholder's death, and that the lower court could determine what the reasonable price should be for that process, and its determination was correct. And so, the question is, what are the lessons of this case? It's reasonable to think that that the brothers, if they were both alive, would not want their family to be fighting over the value of the business and what ought to happen. And so the question is, how could litigation have been avoided in this case? Well, I think the tips are things that those who work in the buy-sell marketplace should take to heart. The first one is that the buy-sell agreement's trigger at death should be mandatory. Remember, the language here said that it was optional, that it was first the business's option and then the surviving shareholder's option to do a buyout. Well, optional buyouts really, in my opinion, don't serve the owners of most companies. Mandatory buyout is more predictable, and you can make plans around it. Both if you're the party who died, family can reliably predict how the process is going to work, as can the surviving owner of the company. So definitely consider making the trigger at death mandatory. Secondly, the parties ended up in court here. They might have ought to put something in the agreement about mediation or arbitration, which could have been less expensive alternatives to both a trial on valuation as well as a subsequent appeal. The most obvious specific recommendation from this case is to create a fixed price or a formula-based value for each owner's business interest in the event of a triggering event. We quoted the language from the buy-sell agreement here, where the parties failed to insert a fixed price, and not only that, from the agreement's inception, they never got back together to come up with a new price to replace any original price. And so that's why the idea of a formula is here. A formula can persistently predict a fair value for the business over time if the shareholders agree to it. In the absence of that, at least coming up with a fixed price and a regular schedule for revisiting that fixed price is a reasonable alternative, and life insurance professionals can help their business owner clients kind of keep track of that. And then finally, fund the buyout price with life insurance. You know, in this case, apparently there was no life insurance to help fund the buyout, no company-owned life insurance, and no cross-purchase owned life insurance to help fund a buyout. If the life insurance was there, it could have helped set the value of the business for buyout purposes, and also could have provided the money needed in order to make it happen. And so all of those are reasonable lessons to take from the Smith case. So to wrap this up, attention to detail saves headaches for all of the parties involved. Simply assuming that the parties to the contract will fill in the blanks later is not enough to really make this kind of thing predictable. If you want to do a good job of buy-sell planning with your customers, then you really need to be rigorous with them and hold them accountable to completing the agreement as well as the funding. And good agents work with their clients and their client's attorney to make sure that all aspects of the buy-sell agreement are covered, including those things that aren't directly related to life insurance. Thank you for being with us today. As a reminder, you can get a newsletter which covers the same ground that we covered today, a copy of the Life Live newsletter. If you email us at asktheexpert@advancedunderwriting.com, asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact Lisa at 615-224-1291. That's 615-224-1291. Thanks again for joining us today. If you feel like you heard something of value during today's webinar, feel welcome to listen again or recommend it to somebody else. We have a YouTube channel. If you need information on how to reach it, feel welcome to contact us at the same email address, asktheexpert@advancedunderwriting.com. And best wishes for continued success.